Any mention?
Any mentioning?
Is it?
What's that? Due to heavy rain, applicants go.
Rain or no rain? You don't want to do, then don't want to do. What to do? Let's see. Yes.
No, this is. This is mentioned.
Yes, yes, Miss Acharya, you want to mention?
My lord, my lord.
Yes. Unmute, unmute.
Item number 36, my lord.
Okay.
There I received information today morning that appellant number, there are 5 appellants. Out of them, appellant number 1 and 2 were the husband and wife. They were at the time of this incident, they were 80 years and 60 years respectively. And they died, Durjadana Jana died in 2023 and Jitta Jana died on 2024.
Okay.
And rest of the appellant are alive. I have already received information about them. So, in this case, my lord, the sole point involved that there is a conviction under section 306 IPC. But there was no specific charge because the charge was under section 302, 304B. So there is a judgment I have seen, but right now I don't remember.
This is a lesser offense.
No,
That was framed in a higher offense.
No. In the there is a judgment of the Supreme Court that in the absence of specific charge under section 306, there cannot be a conviction. I will cite that judgment. So I pray your lordship to take up this matter on 16th.
Why don't you come at 2 o'clock? Nobody is there in the court.
No, not 2 o'clock as today is not possible. 16th,
Okay, 16th.
let it be there. I will address your lordship.
Okay.
And I know that judgment.
Mr. Acharya, learned counsel for the appellant submits that the appellant number 1 and 2 is expired on certain that they can use the rest of the taking persons are allowed, abated for other. Please the matter on 16th. Okay.
Obliged.
Item 1.
In
My
item
lord,
number 1
item
to
1, 2, and 3, the modification of my lord's order. My lord had directed me to file a detailed comprehensive affidavit. Out of 15
Have you verified
cases,
it?
12 cases he has already been
Verified
granted.
it.
I wrote a letter to the IAC on a telephonic instruction. He said the informations are correct, but there is no written instruction to me.
Written instructions have to placed on the
Yes,
court.
Worship. Can it be on Thursday?
Yes, written instruction is awaited from the please the matter. Let the written instruction come on.
My
Yes.
On the 3. Item 4.
Item 4.
Worship,
This case
item
matter
number
text
4.
was sought for regarding
The detention and the whereabouts of the appellants.
Yes.
I have a report regarding the detention. It is of 2023, Your Worship.
There are 2 appellants.
There are 2 appellants. Sir.
Yes.
One appellant, the Bhima Swai, he was residing in his house, and the Bhagwan Swai was inside the jail custody regarding some other PS case, Your Worship. And this is for
But both of them are alive.
both of them are.
Let us go ahead with the matter.
Yes.
Yes, Shogar.
yes, one.
Ready?
Soft copy.
Okay. The counsel for the parties conjointly submit that both the appellants. Paper already prepared.
Yes.
Take the paper.
They are giving the soft copy.
Okay. Both the appellants are alive. The matter is ready for hearing. Mr. Shogar Das, letter counsel for the appellant submits that he doesn't have the copy of the paperwork. He is permitted to obtain the soft copy of the same.
Yes.
Release the matter when?
Well, I will also use this because that.
I am ready even today.
No, I am saying the same days, and then on same days, I'm getting another case for hearing. That is the whole.
Just 11th.
There is a small office, 25 months. Okay. But some pain goes so that I can pay it.
Undergone period also just check it up. Yes.
Item 5.
Worship, item number 5, the appellant is dead. I have submitted the death certificate.
Right.
Yes, I have submitted the
It's
death
the vigilance case, my lord, in fact. In the last,
They got
yes,
the
they have got
committee.
the,
The sole appellant
yeah.
Kamala Kantaroy has expired as per the report that it shows. So everything. Yes.
We tried, but this
And that's a person also right. In the absence of any application under section 394 CRPC by LR or the next friend of appellant. It's evident, yes.
We tried, but they succeeded.
Anyway,
Yeah.
yes.
Item 6.
Got some information.
No report was called for since he was only.
What is the age of this?
He was only 28 in 1999.
In the 50s. He's in 50s.
He must be in.
What is the
50s.
offense, madam?
Convicted under section 325 for 4 years and 5,000 fine.
Yes. What do you say? Have
There
you
are
read
3
it?
eyewitness.
A small matter, you can argue it. Shall I pass it over? Try at 2 o'clock if it happens, otherwise I will. No, you try at 2 o'clock, let us see. If you can do it, it's all right, otherwise I'll let them. Okay, pass over. Just check it up. Period undergone, you just find out. And you tell me at 2 o'clock. Yes.
Item 7.
7, it is a conviction under section 326, 2 year and 1,000 fine.
This is, what was the age of the appellant?
He was 25, 25 in 99. So
Yes.
50 years.
Pass over. Pass. You have decided not to read. I was giving an opportunity. Okay, it's all right. Give it it. Give it it. But get ready. I will not adjourn next time. There's old matters and pass over this matter. Huh? Pass over. If nobody comes, then I'll appoint MLA school. Yes.
Item 8.
This is Mr. Dhaul's matter.
Yes, sir.
May come. 8 years. Tell him, huh? Tell him, the junior or anybody. 8 years.
Item 8.
8. Your Lordship are directed for detention details. I've submitted the copy. Your Lordship.
Yes.
In the meanwhile, he has served his sentence.
Is he alive? Alive.
He is alive. Your Lordship. In the meanwhile, he has served his sentence and.
Already served out.
Yes, Lordship. I've submitted a report. Your Lordship.
Yes, see.
I'm just.
What is the offense?
376 to F. Your Lordship. 10 years of conviction.
10 years served out.
10 years. It seems so. I'll just.
So give that.
He has been released on 1/4/2009 from jail custody after expiry of the sentence.
After expiry of his.
Yes, sir. This is a conviction in the year
But
2000.
conviction is a conviction. Either you have to acute or.
Yes, that
about-
right. That right he reserves.
But nobody is there. Nobody is there. Let us. Persons to the order dated 21/8/2025. The senior superintendent circle jail, Pulwani, has submitted a report dated 27/8/2025 inter alia, stating that the sole appellant, Biro Uttar Singh, son of Binu Uttar Singh, has already been released on 1/4/2009 from the jail custody after the expiry of his sentence period. There is none APS for the appellant. In the interest of justice, this is the matter. Next, Abhijit. Fourth. That is 4th means Thursday. This is the matter Thursday. Okay.
Item 9.
Item number 9. The sole appellant has died, Your Lordship.
Madam, I'm there virtually on behalf of Mr. Panda Violence.
Yes. Pursuant to the order dated 8/7/2025, report has come and he had died. Sole appellant has died on 24/4/2021 Cancel. Declaration. Item number, write down. Item number, yes.
Item 10.
No, item number 10 requires some more time to. I have instruction regarding two of the appellants regarding
Okay, so let's
rest
see,
3.
6 time, huh?
The submitting this. One of them has died.
At a time you give it.
Yes. The day after tomorrow.
Day after tomorrow.
Yeah.
Yeah.
Pardon,
Yes.
my lord, item 80 alert, sir.
Sorry?
Item 80 alert, sir.
8, which one? 8?
80.
Yes, what do you say? 8.
Let's see, no, appear say age.
No, no. She has already undergone entire period. That's the report. Will you argue it or?
Let's see, keep it to some other day so that.
Not, I have
Let-
kept it. Item 8, na? 4th I have kept it. Non-APS kar diyo, 4th record.
Oblige.
She has 10 years sentence. He has already undergone
Right.
that period. Whether you are aiming at acquittal or not, just see. Even if it is convicted, the sentence already undergone, I can do that. But since it is a conviction, you may think of acquittal also. Just check it out.
For final.
4th, final disposal. Okay. No adjournment will be. Yes. Next.
Item 10. 11.
The appellant has been dead.
There is died.
Yes. Submitted.
Sole appellant?
Sole appellant.
The sole appellant is died. Then
11.
11.
Appellant 11 also is dead.
11, I'm talking about 11 only.
11.
12 also dead. 11 and 12 both dead.
Sole appellant?
Yes.
Sole appellant. Just check it out. That is very important. No, sole appellant died. 12. Huh? Then, but, yes.
13.
13 because of time.
Time.
Yes.
She is seeking some time for getting report.
It can be day after tomorrow also.
Day
Any
after
day.
tomorrow, for report.
14.
14, I've submitted a report.
How many appellants are there? Appellant. There are 2 appellants, huh? Rasmi Ranjan Naik died, huh? Three actually. 3, and only who has died now?
3 appellants.
Who has died? Radhashyam Naik, son of so-and-so, village so-and-so, Chandrapada has expired. Okay, Radhashyam Naik. Radhashyam is died, item 3, appellant number 3. Appellant number 3 has died, and 1 and 2 alive.
My lord, Mr. Panda has instructions to appear in this matter, my lord. I pray for
Yes.
a week's time will file fresh wakalatnama.
So so submits that or take a name, IUC Mehta submits that Mr. Devasis Panda is instructed to appear in this matter. They will be filing wakalatnama on behalf of appellant number 1 and 2. Is the matter. Yes.
15.
7.
Seven number of appellants are there. Last occasion, your lordship had called for a report, my lord.
चलो report की सब करूँगा. Ready?
My lord, your lordship may keep it for hearing or some other than.
Today only for hearing only. Get ready, small matter. Why are you not arguing?
On 4th, my lord.
Okay, release the matter. Huh? Yes.
16.
16, instruction has not received.
Not received.
Thank
Okay, not received. Okay. 17.
17.
My lord, we fix a date, my lord. Instruction has not come.
No instruction. has-
Instruction.
No, yes.
You got it.
No, yours.
Oh, instruction is awaiting. Yes.
17.
17 chala.
17.
18.
18 instruction.
How many appellants?
3 appellants, 1 and 2 is there.
1 and 2 have died. And check. Non-APS legal sign, non-APS, and the next day appearing non-APS, MIK will be appointed. January 9.
19,
19, I think for hearing, your lordship, there is no letter for the instruction.
Password. Okay. 20.
20,
20 instruction has not received, your lordship.
Okay. Instruction. Yes.
21,
Lordship, I am on VC on behalf of Mr. Naik.
Yes.
21 CBI, yes. 21
Lordship,
CBI.
may be directed to take,
Yes.
Lordship, we may be directed to obtain whereabout of the appellant.
Already direction is there.
My lord, state was directed to obtain.
No, you, it is directed to you. Acha. By the order dated 15. You know the direction, why don't you do it? And by the order dated 15/7/2025, the direction was issued to the SP of police. To which area? What kind of orders are you? Superintendent of police of the concerned district. You must write it so that the confusion will. Superintendent of police concerned district to obtain whereabout and well-being of the appellant. Now, Mr. Sanket Trivedi, appearing on behalf of Sarthak Naik, submits that let there be a direction to the which police, which SP of which area? You must read it and come. Which area? FIR. Kotak, huh? Kotak. SP, CBI. Kotak. Okay. Yes, next. Next.
22,
Two instruction already expired, your lordship. Sole appellant has expired.
Sole appellant expired. Sole appellant. Sole appellant. Rutu. Ratu.
23,
Instruction of the end.
Appellant could say. Alive, huh? Non-APS, MIK will be appointed. Take it. Yes.
24,
Appellant, your lordship.
The
sole appellant, most probably he is 75 of
instruction as senior.
Instruction available, huh? Fourth?
Four, again.
Yes.
25,
Instruction. 55. Appellant number 1 died.
Appellant number Kalanidhi. What is his name? Appellant number 1.
1.
Karunakar.
Again, Coronago.
Karunakar died on 5/6/2010. Non-APS, MIK will be appointed. Yes.
26,
26.
Yes.
26 ଟା written ଆସିନି but expired ବୋଲି କହୁଛନ୍ତି ମୁଁ ଫିର ବି ଟିକେ
Pass it over. Yes.
27,
27 ଆସିଛି.
Yes. Yes. Report is there. Report is already got. Yes. What do you say?
fourth year last year.
You have decided not to argue any matter.
In fact,
What is the offense, you tell me?
304
Finish it up. These are small appeals, 2006 is pending.
For final disposal, fourth year lesson.
Sorry?
304 part, 7 years.
304 part 2, 7 years. Okay. Please sit. Fourth.
Okay.
Yes.
28,
Complete instruction, yes.
Yes, what is this, sir? Yes. Make it will be appointed. Yes.
29,
29 out of 10 appellants, appellant number 3 and the 7 has already been expired, Your Lordship. That's why I will give answer.
Yes, sir. What is the offense?
Offense, Your Lordship, 321, 324, 34 IPC, Your Lordship, SI for 1 month and RI for 2 years, Lordship, 324 and 34.
Sorry? Appearing for? That's right. I know that. You tell me now, what is this matter? See, 323 conviction, 1 sentence. It's pending since 2006. See, please see, undergone period. I will
So 324
maintain conviction and 323 only.
and 324 is there, RI for 2 years.
324 is also there.
Is there, Lordship. RI for 2
What
years.
is the weapon of offense?
Yes, Lordship, that is exhibit. Yes, body, Your Lordship, use of stick, Your Lordship.
Stick. Recovered.
This way.
It has already been confirmed between them. They're from the one.
Why don't you file it? Then I'll convert it to the period undergone or something.
15th time I will give him.
11th. 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 I will not adjourn. Yes.
item
Next.
30,
30, Your Lordship, one more opportunity, Your Lordship. No,
Yes, one more opportunity. Yes.
31,
31 also same, Your Lordship, one more opportunity, Your Lordship.
Yes.
32,
32 also same, Your Lordship.
You are not, it seems you are not pursuing.
No, what happened, my
Lakshmi does it and Das does it.
my constant to submit, Your Lordship, what happened, the law officer is earlier appearing in this matter, Your Lordship, only wrote letter to the concerned superintendent of police, Your Lordship. But it needs to be concerned IAC, so that is convenient to us to follow up the from the.
How many time you have taken time? You tell me.
Only
I'll
once.
ask the superintendent of police to appear in
That's I'm-
physically. That's the only way things will move, start improving.
Earlier, one occasion that Your Lordship is adjourned this today for Your Lordship. Only once, Your Lordship.
Okay.
33,
33 also same.
Let's see, 33 also same. How many matters you are
Also,
holding like this? Yes. See, this was the direction in 2006 also. Directions were made, thereafter 17th July.
Lordship.
Last opportunity, yeah? Last
Lordship.
opportunity. Otherwise, I have indicated that serious people will be taken.
Sorry, Lordship, I have not obtained the report.
Okay. Next.
34,
34, Your Lordship, sole appeal and expired, Your Lordship, report is here. Yes.
Required.
Yes, sir.
Stand submitted. Yes.
35,
35, no report, Your Lordship.
Same story.
Lordship.
That's 35 on behalf of Miss Nanda. I pray for an adjournment, my lord. She's
Still,
in
the
difficulty.
report is awaited, madam.
Yes, my lord.
Let us see. Yes. Next.
36,
36, Arizona already report is there, 36.
How many
Appellant
people?
1 and 2, Your Lordship, died, Your Lordship.
1 and 2 died, none appears, MIK will be appointed. Yes. Yes.
37,
37, one more opportunity, Your Lordship.
Yes.
Your lordship,
38,
my apologies, your lordship, in item 36, I am appearing on behalf of Mr. Arun Acharya.
So, will you argue? What is the offense?
Your lordship, I pray for 2 weeks' time.
Why adjournment, madam? You can read it and come at 2 o'clock. I'm
Your
just
lordship,
passing it over. Pass over.
38,
Report has come. 36. Yes, 37. What happened? Report is awaited.
No report, Your Lordship.
Report is awaited. Wait. Yes.
38,
38.
38 also no report, Your Lordship.
Yes. 39.
39,
39 also no report, Your Lordship.
40,
40 report is available, sole appeal and expired, Your Lordship.
So the appellant expired.
Report was ready and submitted.
Awaited. Yes.
41.
41 report, sole appellant died, your lordship. Report already submitted.
Same. So the appellant died. Yes.
42.
42, your lordship, one more opportunity, your lordship.
Yes. 43.
43.
Five appellant, out of five, three of them have died and two of them are alive. That's a report.
Non-APS, MAK square will be. What is the offense, madam?
My lordship, it is under section 324 and 326.
What? 324. Okay. Weapon? Find out road. MAK square will be appointed. Yes, next. 44. Now hearing matters. Yes.
44.
Get ready?
Yes, my lordship.
Yes, who is ready for
45 minutes.
45?
Yes.
Pass over. Okay. Yes, anybody is ready? Yes, Mr. Maharaja. Ready? For you, what brief? You can read it from here. Huh?
47.
Give my brief.
Yes.
Give my brief. Yes. Read it now. Yes. Any?
47.
47.
45, she said that keep it as passover. 47 also I am ready.
Ready?
Yes.
Who is appearing for?
And I think the last occasion also nobody appeared. I think your lordship may apply. May
The
appoint
problem, these are PC Act matters.
a Micah's man.
I'll have to appoint MAK.
Yes. 45, 47.
47. Look.
I may be pardoned, my lord.
None
I
has
will-
been appearing for the appellant. Consistent. Mr. A.K. Mishra was appearing at one point in time.
The last two occasions nobody is
The
appeared.
problem is the moment I appoint MAK Skuri, they step in.
प्रकट हो जाते हैं.
And this is very embarrassing situation. MAK Skuri prepares and then let us see, pass over. Let us
Yes.
see, yeah, pass over. We'll see. Yes.
My lord, I may be pardoned, my lord.
Yes, madam.
My lord, item 33, criminal appeal. On your lord, I was trying to join through BC since
It's all right.
half an hour, my lord. My lord, the thing that
Report,
last
1 minute.
occasion,
1 minute, madam.
my lord.
Report is awaited. Okay. Hmm? Sure. 50.
Item 50.
This is against the confiscation, my lordship.
Hmm?
Confiscation, my lordship.
Confiscation.
Yes, ma'am. So very small.
Call serially what to do.
44.
Sir, still raining or outside what?
No, it has stopped.
44.
44. Let us see. Call.
44.
Display board
No.
working?
No.
Yes.
46. 48.
Yes. Which one?
48.
48. Yes.
Lordship, kindly pass it over. Pass it over after lunch.
Pass over. Okay.
49.
Yes.
50.
Please ensure the display. Yes.
51.
51, my lords, on behalf of Mr. Panda, I pray for an adjournment, my lords.
Why, madam? This is 95 matter.
My lords,
What is the offense? What is the offense?
my lords will collect the soft copy because we are not being able to trace out the file, my
For
lords.
collection also you have to come to the court.
My lords, in the second half, I'll
please.
come and collect it, my
Yes,
lords.
you please come. I am passing it over. Yes.
Mm.
Pass over.
Pass over. 52.
52,
52, I pray for a passover, my lords.
Passover.
53,
Hon'Ble.
Your Lordship, I have 5 matters today. I'll be arguing one, but for
Congratulations, you have a lot of matters. But this is the 5th one you have to argue.
Your Lordship, I'll argue this, but I need some time to prepare for this one.
What is the offense, you tell me, let us see. We'll read together the file. Just see, madam,
The item.
Mrs. Marana,
Yes.
just see. What is the offense?
My Lordship, 53 item, okay?
53. 53. Check it up. It's a small matter, then we can finish it up. Offenses are 307 and Arms Act and all. Conviction under
324.
324
324
and 149
then exclusive.
9 we exclusive act.
Section 149 of
1 year 6 months.
yes.
Okay, urgent. It needs hearing. Yes. Yes, next.
54,
After time.
No instruction.
No instruction. But today done that. Now we'll the list.
Let us see what are the offenses.
I don't have the file also.
My Lordship, 20.
NDPS.
Yeah, 20B and 47A of Bihar and Odisha Excise Act. There is the 3 bags from 3 bags content of 6 kg of ganja and 4 kg of bhanga.
Four-year sentence. Yes, what do you say? Will you continue appearing or you will not appear in this matter?
No.
You will appear on behalf of appellant request. Yes.
55,
Yes. None is there. Yes. 56.
56,
Yes, madam.
Your Lordship, the petitioner has been convicted under section 457, 390.
Now you can't take the plea that I have 5 cases. 1 case I have adjourned. Now it has become 4. Okay, very good. Argue. Yes.
Petitioner has been convicted under section 397, 376 and 511 of IPC. So Lordship, before I further with my arguments, I would like to present the facts of the case.
Yes.
So on 7th April 1994 at around 10 p.m. while the victim, that is petitioner 1,
First you tell your name.
Chetna Prakash.
Chetna Prakash. Okay. Yes.
While the
Then you tell me of charge conviction under
under section 457, 397, 376 and 511 of IPC.
457,
397,
397,
376
376,
and 511.
511. Okay. Convicted.
Yes, Your Lordship.
Sentence
8 years of rigorous imprisonment along with fine and 6 months of simple imprisonment.
yes. Undergone period period undergone. You find out and tell me. Huh? Tell me the facts.
Your Lordship, on 7th April 1994, at around 10 p.m., while the victim, that is PW1, was sleeping with another PW7, which is Rita Samal. She was a 9 years old girl at the time.
someone flashed a torch light inside her bedroom and she apprehended danger. She woke up and tried to find out who was flashing the torch in her bedroom, but she couldn't find anyone. So thereafter, the prosecution witness file, which is Rabindra Pradhan, who was the Hodia of this PW1, he came and knocked at the door, and she woke up again and narrated the incident to him. And they decided that PW5 would stay at her place in order to protect her and PW7.
Yes.
And he slept outside the room of PW1. And thereafter, around midnight, what happened is the accused, the petitioner herein, he entered her room and he disturbed her. He then dragged the victim from the cot to the floor, due to which the bangles the victim was wearing broke. There was scuffle between the victim and the petitioner. He then threatened to stab her if she shouts. However, the victim shouted and woke up the PW7 who was sleeping with her and narrated the story to her and told her that you should go and say this to your father. So this PW7, she even threatened the accused person that she'll narrate the entire incident to the to her father. However, after that, the accused dragged the victim to the veranda and she saw Debraj, which is who is another
In item number 10, we have got the report, Your Worship,
Got the report?
given.
What is the report?
3 of them have died.
Out of?
Your Worship, there are 2 appeals. One is 309 and the other one is.
No, no. How many accused are there? Appellant rather.
There are 5 appellants, Your Worship.
अच्छा 3 of them died, huh?
3 of them have died.
10 report मिला. ठीक करते. ठीक है? Yes.
I'm submitting 2 reports regarding.
Item 45.
Yes. Yes, 45, sir. 45. 45. Yes. Action for the offences under section 51C of the Prevention of Corruption Act 1997, read with section 409 of the Penal Code. The appropriation case of alleged misappropriation, the appellant was working as a forest guard. Yes. And was in charge of the stumps that were stored in an open field. And it is alleged that at the time when he took over charge from his predecessor, he had received 31,007 number of stumps as per the charge report. From his predecessor, he took over the charge in the year on the. You got the written note? Yes.
Just now.
Yes, and submitting the written note. It is stated that he took charge in the year 1984. And it is alleged that when vigilance inquiry was taken up, these stumps were not found. Okay. And accordingly, misappropriation was alleged. In order to, the plea of the appellant is one of denial, and he has further taken the plea that there was no physical verification of these stumps at the time he had taken charge. And in order to substantiate the charge, the prosecution has adduced the evidence of 7 numbers of witnesses, yes, out of which PW1 was the forest guard Chakradhar Patel, from whom the appellant took charge of the stumps.
Predecessor.
His predecessor. PW2 and 4 were the watchmen who were guarding the area. PW3 is the head clerk in the office of the DFO, who speaks about the taking over of the charge of the appellant. PW5 is the range officer vigilance, who had valued the stock of the stumps at rupees 6,000. Yes. Valued the articles at rupees. Who PW? PW5.
5 minutes.
Then PW6 is the investigating officer, and PW7 is the sanctioning authority. Okay. So, first of all, I will take your honor to the charge. Your Lordship may kindly come to the charge. Yes. Lordship may. Charge से एक बात कर दूँ. वो मैं जानने की चाहूँगा. और करो. Lordship got the charge. Yes. Para 2, that you, Abhay Kumar Behera, while employed in the Forest Department under the government of Orissa during the period from August 82 to October 82 in the capacity of a public servant as Forest Guard, Forest Division, Bolangir, fraudulently misappropriated or otherwise converted to your own use 31,007 numbers of high stumps of different species worth of 6,000 entrusted to you or under your control as a public servant, and thereby committed the offence under section 51C, punished under 52 of the Prevention of Corruption Act, and within my cognizance. Secondly, that you, Abhay Kumar Behera, during the aforesaid time and place and in the said capacity, having been entrusted
with a dominion over the aforesaid property committed criminal breach of trust in respect of that property and thereby committed an offence under 409 IPC. So my emphasis is on the time period that has been given. Lordship may kindly mark, it is written in the charge, it mentioned in the charge that the offence was committed in between the period from August 82 to October 82. August 82 to October 82, I was not in picture. I took over charge on 13/11/1984. Lordship may kindly come to the deposition of PW1.
Charge on?
On 13/11/1984, I took over charge. Lordship may kindly come to the deposition of PW1, my predecessor. In 1984, Lordship, may I place?
Yes.
In PW1, Lordship. In 1984, I was forest guard at Banji Dongri Nursery. I was in charge of that nursery. Sridhara Joshi and Khali Chapa were working as watchers in that nursery. The plants, stumps, materials, and the papers of the nursery are all in my charge. I was transferred from that nursery and accused of Kumar Vera relieved me. I made over charge of the nursery and all the material papers to the nursery to the accused. A charge list was prepared by me. Exhibit 1 is the charge list. Then Lordship, there were 31,007 number of stumps and accused took charge of these stumps with other items. Then Lordship, the evidence of PW3.
No, when he doesn't say when he gave the charge.
1984 he says.
Where is that? Exactly. Date?
First line. Lordship. PW1 first
In
line.
1994, I was forest guard.
Yeah, Lordship. In 19, I was forest guard. So I was in charge of that nursery. Then I handed over charge. So it was in 1984. The exact date is there, Lordship. PW3, the head clerk of the office. PW3 says that, Lordship.
PW3. Let us see.
PW3, Lordship.
Yes.
In
First para.
the accused took over charge from C. Patel on 13/11/1984.
Last but 3 nights.
13/11/1980.
Yes, Lordship. And moreover, Lordship, if your Lordship will see the sanction, the order of sanction also says that the offence was in the year 1984, which is not the charge. So on this ground alone, the case falls, Lordship. Then coming to the merits of the case, Lordship, in a case of registered under section 51C, which corresponds to 13(1)C of the present act, and section 409 of the penal code, the two most important ingredients are entrustment and misappropriation. These are the two most important ingredients to prove criminal breach of trust.
Yes.
Now, Lordship, in the instant case, PW1, the person who gave over the charge to me,
Entrustment.
says that the charge list was prepared and he had handed over the stumps and the stumps were calculated. That is what he says. But evidently at that time, the watchmen who were present,
2 and 4.
2 and 4, they do not support. They say that there was no physical counting of the stumps at that time. PW2 and 4, Lordship. May I take, Lordship, to the evidence of PW2, Lordship, first. PW2. In 1984, I was working as watcher in Banji Dongri Nursery. PW1 Chakradhar Patel was the forest guard in charge of that nursery. I was relieved from the nursery in October 30th, 1984. Stumps of different species had been kept in that nursery, but those stumps are not counted in my presence at any time. then he is declared hostile by the prosecution, and then may I take lordship to the cross-examination in para 3. In between 1982 and 1984, stumps of different species were collected from the forest and was staked in Bandi Dongari nursery. PW1 was in charge of engaging workers and maintaining master role of those workers in the stumps collection work. On occasions, the stumps used to be nursery on the very same day of cutting. On other occasions, the stumps were brought after some time or days of the cutting. Bullock carts were hired to carry the stumps from the forest to the nursery. Khali Chapa, another watcher, was supervising the loading and unloading of the stumps. I cannot say if the stumps were being counted. A stock register was being maintained for the nursery, but the stumps were not being entered in the stock register. Sometimes the cook used to burn the stumps as fuel. Sometimes some stumps were also being damaged by weather and white ants. I cannot say if PW1 ever distributed these stumps. So this is, then I will take lordship to the evidence of PW4. PW4 is another watcher. He says, in the year 1984, I was working as a watcher in the Bandi Dongari nursery. I was present at the time when Chakradhara Patel, the forest guard, handed over charge of the nursery to the accused, namely Abhay Kumar Behra. We brought the stumps from different places of the nursery, and after having counted the same, stacked those in one place. Sridhar Joshi, who was serving as a watcher under the forest department, assisted me in counting the staking and of the stumps. I do not remember the year in which I brought the stumps and stacked those at one place in the nursery, since I am an illiterate man, where when we stacked the stumps, we did not count
Para
the
3,
same.
para 3, come to para 3.
Lordship,
When Chakradhar Patel.
Chakradhar Patel, the forest guard, made over the charge of the stumps to the accused at that time, those were not counted. At the time. Lordship, now the question is, there is an interesting deposition of PW5, the forest, the range officer of the vigilance department, who went to the spot for verification. Lordship, may I take lordship to the evidence of PW5? PW5 says, in the year 1988, I was a range officer attached to vigilance department, Northern Division, Sambalpur. In connection with the calculation of stumps, the value of the stumps which are involved in this case, I was issued with a letter by the Inspector of Vigilance on 2/1/88. As per the letter addressed to me as stated above, I calculated the stumps which the accused had taken charge of. The number of those stumps were 31,007. It is in 88. It's a peculiar case, Lordship. He says that he went and calculated. And then he assessed the value at rupees 6,000. So, and moreover, Lordship will find from the entire evidence, there is no evidence that the prosecution has not led any evidence that the stumps were missing.
Yes. Yes.
May it please.
You first answer. Charge says 1982.
Minus.
And he takes charge in 1984. PW5 says that 1988 I calculated. What is this?
There is some discrepancy so far as the date is concerned, but that is not fatal to the prosecution case. The Lordship may kindly come to section 464 of CRPC for a moment.
Here. Here.
Date is very material in an offense under 409. Charge mentions that date is to be stated.
409 is not only the standalone offense, 51C is also.
51C.
Yes, 400.
464, man.
Same. Date is 12.
464.
You tell me. 464, yes. 460. Yes.
My lords, may I just place it?
Hmm.
Section 464 CRPC. Effect of omission to frame or absence of or error in charge. No finding, sentence, or order by a court of competent jurisdiction shall be deemed invalid merely on the ground that no charge was framed or on the ground of any error, omission, or irregularity in the charge, including any misjoinder of charges, unless in the opinion of the Court of Appeal, confirmation or revision, a failure of justice has in fact been occasioned thereby.
Yes.
If the Court of Appeal, confirmation or revision is of opinion that a failure of justice has in fact been occasioned, it may, in a case of an omission to frame a charge, order that a charge be framed and that the trial be recommenced from the point immediately after the framing of the charge. In the case of an error, omission, or irregularity in the charge, direct a new trial to be had upon a charge framed in whatever manner it thinks fit. Provided that if the court is of the opinion that the facts of the case are such that no valid charge could be preferred against the accused in respect of the facts proved, it shall cause the conviction. Now, here the appellant was very much aware about the nitty-gritties of the accusations that he is facing. Thereafter, my lords, in the recent Supreme Court judgment of 2012.
No, he doesn't say that the charge is wrongly framed.
Yeah.
What he says is the charge only talks about 1982.
And how it comes to the failure of justice?
But see, in that context, he says that 1984 I took the charge.
Yes.
So if the offences have already taken place in 1982, that time he was not in charge. That's what his case is. He doesn't say that the charge is defective. He said, let the charge be there, no problem.
Error in charge, my lords. Error in charge.
He is trying to derive benefit reading the evidence of other witnesses.
Yes, my lord. That is the error in charge, my lords. Up to a maximum extent, it will.
The offence, the charge, citation of the charge indicates that the offence has taken place in 1982.
82.
But he has taken charge of as a guard from PW1.
Yes.
That is in 1984. And PW3 specifically gives a date.
But in my respect.
What is your case? Whether the offence has been taken place in 1982 or 84?
84, my lords. Where he has joined, my lords. Because Exhibit 11 clearly establishes the interestment part of the accused. But before that, I will just place one judgment on the factum of charge, my lord.
There you are clear. There you are clear. I am not on.
My lord, I'm so
quarreling there.
I am so good.
But the only what is troubling is PW 2 and 4, both of them say that it was never calculated.
My lords, if your lordship may
Interestment, how will you?
Exhibit 1, your lordship.
Clear interestment is not coming out from the record.
In my humble submission, my lords, Exhibit 1 is the charge report where the appellant admits that he has received these stumps. Your lordship may kindly glance to the Exhibit 1, my lords, the charge report. And this Exhibit 1, my lords, have been proved and got corroboration with PW 1 and 3 also.
Yes.
My lords, may kindly see the Exhibit 1, the charge report.
Yes, I'm there.
Item 29.
Yes.
31007 high stumps he has received, my lords.
Where is that?
Item 29
20.
of the charge report, that is Exhibit 1.
29.
And this has been corroborated by
31007.
Yes. He has received that much. He has received that much of stumps. He has taken charge of these stumps. So this is clear entrustment. And this further.
In 1988, it was calculated again. The same number stamps.
Yes.
How can it be possible?
If your lordship may kindly come to the evidence of PW 1 and 3 for a moment.
Yes. See, that is how he is creating it out on the evidence.
I understand.
1988, PW5 goes the same number of stamps. As if nothing has happened. 1984 to 88.
But the charge report itself establishes that he has received this much of stumps. What more is required? In my humble submission, when the appellant himself admits that he has taken charge of this number of stumps.
No, see, the problem is PW5, who is a officer of your
Range
own
officer,
officer,
range officer, my lord.
range officer, own
Yes.
officer. He is trying to camouflage everything. Then you are trying to build up a case against him. It appears, looks like.
So far as exhibit 1 is concerned,
That
my
is
lord,
his case.
my-
That
it is his case.
That is his case.
I don't dispute that, my lord. So far as exhibit 1 is concerned, my lord, it's a charge report which has been acknowledged by the appellant himself, saying very well that I have received this number of stumps, my lord.
Where
So,
is his signature?
it's there, my lord.
Exhibit
1.
On the last page.
I think so far as the factum of entrustment is concerned, it is very much clear when he himself admits that I have received this much of stumps. So where is the question of doubt, man? And this further corroborates with the evidence of PW1 and 3. If your lordship may kindly come to PW1, the predecessor. I will just place it once again.
Yes.
Lordship may kindly have it.
Yes, read it.
In 1984, I was forest guard at Panjipungri Nursery. Bajidangri Nursery. I was in charge of that nursery. Sridhar Joshi and Khalid were working as watchers in that nursery. The plants, stumps, materials, and papers of the nursery were all in my charge. I was transferred from that nursery and accused. Abhay Kumar Behra relieved me. I made over charge of the nursery and all the material papers of the nursery to the accused. A charge list was prepared. Now, this is important.
This is exhibit 1.
Yes, exhibit 1. A charge list was prepared by me showing the items which I made over to the accused. After taking over charge of everything, myself and the accused both signed on that charge list. Exhibit 1 is that charge list. Exhibit 1 by 1 is my signature on it. The accused signed in my presence in the charge list. Exhibit 1 by 2 is a signature in the charge list. All the items were counted before the charge was made over. Myself and the accused jointly counted the stumps among the other items.
Yes.
There were 31007 number of stumps and accused took charge of these stumps with the other items.
Exhibit 1 is proved.
Exhibit 1 is proved. Entrustment part is very clearly proved. The appellant himself has endorsed that he has received this much of stumps. Then your lordship may kindly come to PW3 matters. Who is the head clerk? He also proves exhibit 1, the head clerk matters.
PW?
3.
Yes.
What you have it, man?
Yes.
I was the head clerk under the control of DFO, Afforestation Balangir from May 1983 to January 1992. I know the accused Abhay Kumar Behra, who was serving as forest guard under the control of DFO Afforestation Balangir during the relevant time. I also know Chakradhar Patel, forest guard. One forest guard remains in charge of central nursery. All articles in the nursery, including the stumps, remains in charge of the forest guard. There is a central nursery located at Banji Dungri. Chakradhar Patel was the forest guard in the aforesaid Banji Dungri nursery. The accused took over charge from Sri Patel on 13/11/84. So far, the aforesaid nursery is concerned. A charge report was prepared in this context, which was received in our office on 17/11/84. Exhibit 1 is proved.
So even if entrustment is proved, then where is the breach part?
Minus, can you come to PW5, the range officer?
Yes.
The evidence of PW5 minus the range
That's
officer.
very difficult evidence.
And that
If
is
the
only-
breach, suppose entrustment is established.
Yes.
Okay, I'll take it. That entrustment is proved. You have to bring the breach.
Yes.
Which you would witness.
Plus PW5, I will just place it.
PW, I will not believe PW5. PW5 is difficult. Except PW5, if you have anything, breach part.
Minus.
Entrustment, okay. Exhibit 1 is proved
Yes.
through PW1 and 3.
Yes, ma'am.
And he himself has signed it.
Yes.
Okay, to that extent, it's all right.
PW5 came to this spot in 1988.
That's right, but
That's what
see,
my lords is
on that, I'm examining the breach part.
Yes.
Unless the entrustment may be there.
Yes.
If unless you prove it, there is a breach. 3409 is not made out.
Yes.
Successfully, you could prove, okay, entrustment. How will you bring the breach? Through which evidence?
And that's, I think.
PW5 steps into 1988. Just forget it. These stamps are not such articles which will remain for 4 years. And exactly the same number. 31,000 whatever. 31,007.
Yes, 31007.
So entrustment is okay, but breach is difficult.
Yeah. My lord, Exhibit 3 is the report of that range officer, my lords. Because my lords, he is the only witness who could prove the breach in my respective submission, my lords, the range officer. So also the predecessor, my lords, PW1.
PW1 only proves entrustment, doesn't prove the breach.
He says that he has been given the charge of.
That's right. I agree.
Yes.
I agree with you.
Yes.
Breach part.
Breach part, my lords, I will be only relying on the range officers.
5 I will not believe.
For a-
Except 5 if you have that, just think over.
There
That's
is
the
no-
problem with you. That
Honesty, there is
see,
no-
it looks like 5 is a planted witness. You could have been little wiser, little bit here and there. You could have done it instead of that straight away same number of stamp 31,007, exactly the same number. How will you have to prove beyond all reasonable doubts? He has successfully created a doubt in so far as.
Your Lordship,
entrustment
kindly
part.
examine Exhibit 3. If your Lordship admits Exhibit 3, I have a case.
Let us see exhibit.
If your Lordship doesn't admit Exhibit 3, then I don't have.
Exhibit 3 is through.
It's range officer, PW5.
Just leave aside PW5. Minus PW5. Anything came through PW5 has no meaning. Because the PW5 is not a trustworthy witness at all. He is a planted witness.
So all we have is PW5.
That's the problem.
May I, just 1 minute, may I take lordship to the evidence of PW4, the second page, line number 1.
Yes.
PW4 lordship. The Banji, second page lordship.
Yes.
The Banji
Nursery is an open place. And you see, through the evidence, you have said that few guards are using for cooking purpose. It may be.
He says
From that score, my lord, the appellant could have informed the higher authorities.
So then therefore, even if you in 1988 when you examined, instead of giving this exact number, you could have said that it is something and less than that. Then also you could have believed.
But in 1988 also he finds the same number.
That is the whole difficulty. If you would have said little lesser than that, I could have believed, okay, it may be correct.
Then
That's the whole difficulty. If planted witnesses are, you want to tell the.
Interestingly, PW1, PW2, PW4 all agree that a stock register was maintained. The stock register has not been either been produced nor proved in the case.
So far as breach part is concerned, my lords, I would be only relying on Exhibit 3 and PW5 because there is no other prosecution witness who are supporting the breach part. It is your lordship's fine sense of justice to admit Exhibit 3 or PW5.
I have submitted the note and some citations.
Yes. Evidence there. If you want to give it. Citation also, if you want to give, please. If you want to give citation, please. Yes, sir. 1 minute. In a council.
Matter before your lordship today.
75.
75.
I am hard pressed. If time will not permit, somebody will mention and.
When do you want? You tell me because the other people are ready to argue.
My lord, on 8th first case, I will.
8th first case. On 8th.
No, 9th.
9th.
First case, I will.
Ninth.
complete.
I will sit now, continue sitting. I'm just coming within 2 minutes. I'll get you.
He thought that.
He thought that I'm already exhausted. I'm not. I'll just come with 5 minutes.
additional was forced to say instruction regarding the.
It hasn't come. It hasn't.
Only of the accused, and I met him today, this broadcast is another notification. That day, which is listed on immediate.
33. 33 की नहीं.
Additional evidence
Huh?
for the
Report is not necessary. Appellant is saying. कोई नहीं. Report is not necessary. 33. Simply let the counsel for the appellant submits that the appellant is here in hearty and no report is required to be sought for. Appeal is ready for hearing. Please see matter. When do you want?
Monday.
Not Monday.
Next week.
Next week. 16th. Yes.
59.
Yes. 33. For you.
59.
Cut off file दिया.
There are two matters.
Two matters.
One already disposed of. Another has been.
Yes. One disposal means.
That is 19
The report. Yes. Okay. Get ready. Yes.
What's about after lunch?
56. Yes, anybody is ready?
65.
65 kitla.
Item 65.
Yes. Yes.
Here, my lord.
65.
Well, convicted under section 20B 2B of 2BI of NDPS for a period of 3 years. Fine is 5,000. 20B I of NDPS Act.
B.
My lord. 20B I of NDPS Act. 3 years and fine is 5,000. My lord.
3 years.
Fine is
5,000.
5,000. My lord.
Yes.
Here, my lord, total prosecution witness is only 3 witnesses, my lord. And section 50 has not been complied.
Yes.
No gazetted officer or in absence of any independent witness, my lord, seizure has been made.
Yes.
Only one independent witness. Somehow he has also not corroborated to the
Yes.
PWs.
Yes.
And the investigating officer, my lord, he himself lost the PR.
What is the recovery?
Recovery, my lord, 2.5 kg of ganja
2.5 kg.
from 2 person while they were traveling in a
kg of ganja?
my lord, from 2 person.
From? 2
One
person.
Luna.
Yes.
Transporting in a Luna, my lord.
Okay, both these appellants.
My lord.
Yes.
So far as section 50 has not been complied with.
Let us see.
Only 3 witnesses, my lord. Prosecution witness.
Yes. Who is PW1?
Beg pardon?
PW1?
PW1 is the independent witness.
Yes, ready.
My-
PW1.
I know the accused person in the dock. About 9 or 10 months back, I had been to Gurujanga to procure coal. On my way back at Khurda Gurujanga Road, I found the accused person riding a Luna from Khurda to Gurujanga side. Accused Manoj identified was driving the Luna motorcycle. Accused Lakshmidhar Behra was sitting in the pillion. The excise official which
Intercepted.
Back.
Intercepted them.
Yes, ma'am. They also asked me to remain present. At about 10 to 15% gathered at the spot, a bag was tied to the handle of the Luna of the accused person. The excise official wanted to search the bag. The excise official wrote something and told the intent to take him to their house. I have signed in the writing. The accused person also signed in the writing. The excise personnel gave their personal search and to me, the accused person, and nothing was found on their person. The accused person also searched the excise personnel, nothing was recovered from them. Thereafter, the excise officer proceeded to search the bag tied in the handle of the Luna. The accused person were riding and found the ganja. On the women, the quantity of ganja was came to 2.5 kilogram. The excise official wrapped the seal, the bag containing. The excise people seized the bag containing the ganja. Exhibit 5 is the seizure list and Exhibit 5/1 is my signature thereon. The content of the seizure list was read over and explained to me. The other search witnesses signed in the seizure list. But they have been not examined, my lord. The other witnesses.
Who? Other?
The other search and seizure witness on the seizure list.
Yes.
But they
The
have
other such
seizure
witnesses signed on the not examined.
My
Not examined.
Interestingly, they have been produced by the defense witness. They turned to defense witness. DW1. Cross-examination. It is not a fact that SI has married to my sister. Samantrapur is situated at a distance of from Khurda. I have read up to 7th standard. I do not know the excise Bali Sethi, there were about 5 excise officials at the spot. They were uniform. They went to the there by a tracker. I do not know the recollect the registration. The excise official intercepted the accused person on the road a distance of about 100 to 150 meters from Gurujanga Chowk. The Gurujanga crossing is a trial on the road leads to Haldia and the main road leads to Khorda to Gujarat. It is not a fact that I have not seen the accused person riding in the Luna. The accused person were riding the Luna from the opposite direction and I have seen the excise official their chapter. The accused person at a distance of 15 cubit, I cannot say the rank of excise official who asked me to join them in searching. The accused person, I do not know non-official who gathered at the spot at the time of seizure. The accused person took me search as per the direction of excise official. The excise people also took my personal search, but I cannot name the official witnesses. MO1 is a white colored plastic bag, excise personnel had only carried some papers. The women appeared of the excise official made the women accused Lakshmidhar had once called on me to shop at Samantrapur. I had not gone through the writing and excise official had read over and explained the writing to me. MO1 was sealed with the decimal signature of a brass and I cannot say at whose custody the seal was after sealing.
Yes.
This is vital, my lord. I cannot say at whose custody the seizure kept after sealing.
Yes.
The excise official had requested me to keep the seal in Jimanama, but I declined. The facsimile impression of the seal.
Where have you read it?
46, page 46, my lord.
46, yes.
Paragraph 10. The excise official.
Requested me to keep the seal in Jimma.
The excise official had requested me to keep the seal in Jimma, but I declined. The facsimile impression of the seal is similar as the seal handwritten, my lord, which is read over and explained to me as MO1. All the exercise took
only
about
ganja that was kept in MO bag. All
that
the
was
exercise
which is
took about-
read over.
Yes.
And Samantrapur is situated at a distance of 1.5 kilometers from the seizure. It is not a fact that MO1 was not seized from the possession of accused. It is not a fact that I am deposing falsehood at the instance of SI of Sethi.
Yes.
And interesting, my lord, paragraph 12, my lord, on further re-examination, he stated that
I have wrongly identified the
yes, my
plastic
lord.
bag.
I have wrongly identified the plastic bag in CMR number such and such. The containing bag seized in the ganja due to inadvertently MO3 plastic containing ganja CMR. No source to me in the material object which was seized from the accused person.
Something else was shown to him.
My lord.
Yes.
Further
Very clarified.
examination he declined, my lord. In the statement of IO, my lord, IO admitted that, my lord, the women machine was with him, my lord. Women machine.
The MO was missing.
No, my lord. The machine was with him, my lord. While he was traveling, conducting raid, my lord.
Which machine?
The women machine, my lord.
No,
What is the necessity, my lord, to keep him prior to seizure?
He was carrying with him.
Yes, my lord. He admitted in the cross-examination, in the examination in chief also.
That may not be very vital.
My lord.
But you say 50 is not complied.
He is not complied, my lord.
How?
Only one independent witness. As per section 50, my lord, there must be 2 independent witness or respectable person, my lord.
Yeah, NDP. And the 2 witnesses, seizure witnesses, have not been examined by them. Rather, you examined as it.
Yes, my lord. The defense witness also admit that, my lord, he was examined during trial investigation.
Yes. Number section 50. Yes. Yes. Read.
Yes, my lord.
Which provision?
Section 50.
Yes.
Subsection 5, my lord. When an officer duly authorized under section 42 has reason to believe that he is not.
1 minute. Yes.
Subsection
Yes.
5, my lord.
When an officer duly authorized under section 42.
Reason to believe that it is not possible to take person to search to nearest gazetted officer or magistrate without the possibility of the person to be searched patting with possession of any narcotic drugs or psychotropic substance or controlled substance or article document, he may instead taking such person to the nearest gazetted officer magistrate proceed to seize the person provided under section 100 of CRPC. Section 100 CRPC says that, my lord, there must be two independent witnesses.
Yes.
Section 100 CRPC, my lord.
Yes, read it. Yes.
Yes, my lord. Section 100 CRPC governs search of closed place, requiring those in charge to allow entry and facilitate for lawful search upon demand and production of warrant. If entry cannot be gained, the officer may use measuring similar to this section 47. The procedure also mandates that search are conducted in presence of two or more respectable persons.
100 close to.
Yes, my lord. The procedure also mandates the search are conducted in presence of two or more respectable persons. Independent resident of locality, a list of seized item is prepared and signed by the witnesses, and personal search of individual are conducted with due regard to the decency.
Who are more respectable and independent. Yes. Yes.
And that apart, my lord, the seizure letter has not been given to any Jiman. Under whose custody the seizure article was given, he has not been examined.
Let us see the PW3.
PW3 is the IO, my lord.
IO, what does he say?
IO, he himself the informant and the investigating officer.
What does he say?
Page
He
53.
gave Jima to whom?
Page 53, my lord.
53, yes. Come on.
I was posted as exercise of SI Bhubaneswar, such and such. I had been to Khorda site with staff of for mobile patrolling duty at about 4 p.m. I, along with my staff, performed patrolling duty on Khorda Gurujunga Road at a place of where Khorda and Gurujunga at distance. I found accused Manoj Sahu, identified, was riding a Luna from Khorda to Gurusinga side with accused Lakshmidhar Behera, identified on the pillion. On being suspicious of the demeanor, I intercepted them, and at that time, two persons were coming on the road. One of from Gurujunga side, namely Birokishore Sethi, PW1, and other from Khorda side, namely Prabhat Kumar Das. I requested them to join in the searching. The accused person were carrying cement plastic bag hooked to the handle of Luna. In the presence of witnesses, I informed the accused person wanted to be searched in presence of Hon'Ble, a magistrate or a gazetted officer of any designated department, and I serve a notice on them exercise their option aforesaid. Under section 50 of NDPS Act, exhibit 1 by 1 is the copy of the notice. I have served on accused Lakshmidhar Behera, and exhibit 2 by 1 is the copy of the notice. I have served on accused Manoj Kumar Sethi. Exhibit 1 by 3 is my signature, and exhibit 1 by 4 is the signature of Lakshmidhar Behera thereon. Exhibit 2 by 3 is my signature, and exhibit 2 by 4 is the signature of accused Manoj Kumar Sahu thereon. Both the accused voluntarily consented to be searched by me and also gave the consent in writing. Exhibit 3/1 is the written consent of the Lakshmindar Behera. Exhibit 3/3 is the signature of accused Lakshmindar Behera. Exhibit 3 is the signature of witnesses Biro Kishore Sethi, PW1, and Exhibit 3/2
They
is the
say PW1 and PW2
My
are the 2%.
2%.
100 section 100 comply. The independent witnesses. Talks of independent witness.
But there is only one independent witness. PW1 is the.
But they say what the trial court goes saying that PW2 is also one of them. So two witnesses are satisfied. Yes.
Two independent witness or respectable person. Section 50.
Give them option.
Yes, ma'am. And written consent of accused Manoj Kumar Sahu. Exhibit 3 is the signature of accused Manoj Kumar Sahu. Exhibit 4 is the signature of witness Biro Kishore Sethi. And Exhibit 4/2 is the signature of Sarpanch Pradhan, ASI PW2, who was with
PW2.
me on patrol duty. Before proceeding to search the accused person, I gave my personal search to the accused person in presence of witnesses, and likewise the witnesses also gave their personal search to accused person. I searched the accused person, but nothing was recovered from there.
I carried the weighing machine with me.
My lord. Paragraph, page 55. He admit that one. I weighed the bag containing ganja by the payment after I had carried and found it was weighed to be 2 kg 500 gram. He himself carried the machine, my lord. From this smell and texture and from my experience in excise
Thereafter
department.
I affix my brass seal on the paper slip. Chemical examination report.
Chemical examination report is there.
Yes. Exhibit.
Exhibit 9, my lord.
It is proved through whom?
He has not been examined. Only chemical.
57.
Yes, ma'am.
Is.
Exhibit 9 is the chemical examination report. After completion of investigation, I submitted PR. MO3 is the sample which was drawn by the SDGM and sent to the laboratory for chemical examination.
Gives positive identification.
No, this exhibit is brought through whom? PW2. PW2. Just see now PW2 how it has brought on record. How it has been brought on record. How this chemical analysis report was brought on record? When none was examined from the laboratory.
Yes. The independent witness he has also declined. I have not given the
Page 50.
Seizure was from both the accused person. They acknowledged teaching. The SI arrested the accused person. Accused person were forwarded to the court on 5/12/98. The SI produced the MO1 before the special court on 18, along with the accused. As per the direction of the special sample, sent to the state drugs test laboratory for production of Exhibit 6 is forwarding report. On the very next day, I produced the sample in the state drugs the junior scientific officer on the laboratory knowledge, the receipt of the sample.
Exhibit 9 was brought on record by whom?
Paragraph, page 51, paragraph 11. The sample were drawn by the SDGen in charge before the 4 p.m. in the chamber of SDGen. I do not recollect the name of the SDGen in charge. The SI of Excise Malkhana clerk and myself were present inside the chamber of SDGen while sample were drawn. The seal put up on in the MO1 by SI of Excise was broken and kept in a separate seal covered by the SDGen in charge. The Malkhana clerk broke the seal as per the direction of the SDGen. The said seal packet and containing the broken seal was kept in the court Malkhana.
It was kept in Malkhana.
Right.
Then what do you want?
The custodian of the Malkhana, he is also not able.
But he says it's Malkhana, that's not a problem. Just chemical analysis report, how it has gone on record is not coming clear.
No.
Who has exhibited that? Through which witness this has been brought on record?
That is not clarified yet. He says that after the arrest and detection, they have sent it to SDGen. In the chamber of the SDGen, the sample was collected and sent for chemical examination.
Page 57. Exhibit 9 is the chemical examination report. After completion of investigation, it is submitted here on 8 to 99. Demo 3 is the sample.
57 is complied.
The Lordship kindly see page 51, last paragraph. The SI had recorded my statement on the date of detection at the spot. The SI had also examined the 2 other witnesses. But they have not been examined.
That's there. That is for 50.
Yes, sir.
I'm talking about 57 is complied.
Right.
57
is
is
not compliant. Section 50 is not compliant.
50 is doubtful, but
Right.
57
In
is
absence of section 50, my lord, conviction cannot be compliant.
get judgment 2 o'clock. 2 o'clock.
This is the government.
2 o'clock. Madam, you get ready. 50 is not complied, it seems. 57 is complied, I have seen. 50 is not complied. What is the consequence of non-compliant?
Sir, yeah, complaints of
Sorry?
Item 26.
Right, 26. Sole appellant. Report. Shall I record your statement? Right on. 70. I'll just see 70. Yeah? 1 minute. 70 first time. Let me 78. Huh? Take out 78. Do you have the date when he died?
5 years back.
Let it give your name. Huh? The counsel for the appellant submits that the sole appellant Pravir Samala, Pravir Samar, alias Pravir Kumar Sunani. No, Pravir Sunani alias Pravir Kumar Sunani has already expired. 5 years back. 5 years back. Therefore, the appeal has expired its own so in the absence of any application under 324 by either the LRs or the next friend of course, the sole appellant, the appeal stands submitted. Yes, sir. 67. 67 also same lipo. 67 the sole appellant name is same appellant Raghunath Sahu. Same likho council and in the absence of application it stands submitted. Yes.
I'm not sure item 48, the sole appealing is done.
48. By report dictates also pursuant to the order dictates also a report pursuant to the order date 24/7/2025. A report has been received from IIC Dharamsala PS at Jajpur dated 13/7/25 that the sole appellant sole appellant. No, there are many appellants.
They are all convicted by the order of the court.
Huh?
Only one sole appellant was filed this appeal.
No, madam. Item
Item 48, my
48.
same that. Nityananda. The officer was directed to take the instruction regarding the.
1 minute. No, there are many,
No.
but no. See, the appeal is filed 327 appeal number. The appeal is filed by as many as 7 people. Appeal is filed by 7 people, madam.
Let the matter.
Just take it up, take it up. 7 people. Yes, 2 o'clock.
Personal.
नहीं नहीं Yes, what is your name?
Dhirendranath Varik, sir.
There is an appellant who has been convicted for offense 376. He is still there in the custody.
No, sir.
His name, huh?
No, sir.
When he was released?
He was released on 15th February 2001, sir.
15th February
2001.
2001.
Sir.
On bail or what?
On payment of fine, sir.
Payment of?
Fine.
And what about the sentence period? He is already undergone.
Sir.
Okay. He paid 500, huh?
Sir.
What about the other accused person? The same in the other appellants in the might be the same, but it might be the same situation. Anybody is there in your jail who has been convicted and his appeal is still pending? Having sentence less than 10 years or 10 years?
Number of cases are there, sir.
Sorry?
Number of cases are there, those who are sentenced less than 10 years, sir. And that,
No, the old matters like 2001, 2 or something of that sort.
No, sir.
Recently there may be.
Recent cases, sir.
Okay. Thank you. Thank you. Thank you very much. The sole appellant in the present case has been convicted as so sentence so. During the trial, he was the appellant was arrested on 3/10/1993 and remained in custody up till 15 to 2001. The trial court passed the order of judgment of conviction and the order of sentence 88 24 to 1996. Thereafter, the appeal has been pending since 2000. Appeal is pending since 2/7/1996. Meantime, the sole appellant, Munna Behar, has already undergone the entire period. During the first hour, the superintendent of Circle Jail in Barampur was asked to be present in the court through video conferencing mode, and he appeared and informed the court that on 15 to 2001, the appellant has been released as he has served out to the entire sentence. And insofar as the fine of rupees 5 was already cleared, he on that day he paid the fine amount. Hence, he was released on that day. In view of the aforementioned, Mr. Maharaja, counsel for the appellant, submits that nothing survives in this appeal, as the appellant has already been set out regarding the appeal's disposal and appreciation. Appointed. AC चल नहीं AC 65 चल Yes. Where does it say two witnesses? Where does it say? Page 3. Yes. Yes. That's there, it has to be complied, but whether it say that the two witnesses are required to be. But do you have any judgment to that effect? Right, 50 need to be, see, these are the draconian law where the procedural safeguards are there. It has to be complied, no doubt about it. But your contention is 50, there are 3 witnesses were there, seizure witnesses. One witness is examined, 2 witnesses are not examined. Rather, those 2 witnesses are examined by you. One amongst them, you examined by you. And again, the same time, you say that section 100 says that 2 witnesses are required. That is occurring in section 50, clause 5. Read with section 100 of clause 2, subclause 2. But do you have any judgment to that effect? I'll put, see, I want to write a judgment on this, as you get some judgment. Statute is always there. That is not the issue. Issue is what you pointed out, you get a judgment on that. Yes, madam?
Beside Raleigh Secretary served written notice to the active persons giving them option either to be produced before the nearest.
That's not the argument. Argument is there. What he says is, if magistrate is not there, at least 2 independent witnesses are required under section 50. And you have rightly said that there are 2 witnesses, but you have not examined one of them. Rather, he examined the same witness. So section 100 is not complied, 100 clause 2. Therefore, 50 is not complied. That's what is case. Get some judgment, huh? For the you also get some judgment. Yes.
70 reports. I'm 70 reports.
70.
Out of 70. 70.
One correct.
One.
Yes.
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 757.
Yes. Anybody is there who is ready to argue?
Item 6.
Yes. Yes, madam. Ready? Ready? Come. Morning you were saying you are not ready now. Just see. If you read, you will get confidence. What is the offense? Yes.
Nephew of the informant, that is PW1, and one Farooq Rao, who had lately going at each other and at their house. And their sand suddenly fell on the appellant and who was sleeping on the veranda, and for which he gave a slap to PW1, that is. And what happened is that father was the deceased, and PW4 and brother of PW1 is not informant. And they discussed for, and PW4 slapped the appellant. And therefore, the appellant narrated the whole incident to his family. And for which is alleged that the appellant and his father and brother, being armed with lathis, they came to the spot. And in that court, prosecution quarrel ensued. And in that court, the prosecution, in particular, in that appellant dealt a lathi blow. And on the case.
So the father of the informant.
No.
Father of PW1.
PW1.
Hmm.
Then he dealt an active blow on the chest of the deceased. And then on the chest of the deceased who lost his sentence. And while being shifted for treatment, he succumbed to the injury.
Yes.
So this is what about the
Prosecution story. Yes.
And here prosecution would examine 11 witnesses.
Yes.
And no witnesses have been examined from the side of the.
Yes.
So, Your Honor, the defense is a complete denial, and it is specific that injury occurred when the deceased fell on the wooden bed. There was a wooden bed.
You have been convicted in 325. Yes. Yes.
Genesis of offense. Please get to the answer on the basis. After the exam was changed, completely changed during the trial. And what happened there? PW1 was playing cards, and the applicant wanted to take part in that game. And as he was not permitted in the game, for which applicant slapped PW1, and PW1 informed his father, etc. And then applicant dealt a katua blow.
Katua.
And on the chest of the
That is the version of PW1.
PW.
Read one paragraph at least, let us understand. I'm looking to the evidence of PW1.
PW1 and the occurrence narrated in the fact, I have opined that the genesis of the occurrence has found Mr. Pan on the material particulars of the case of FIR lost by PW2. It was stated the quarrel stated to have been ensued due to throwing of sand by PW1, which fell on the accused, but during trial,
it is stated by PW1 that as the accused was not allowed to become enraged and slap PW1.
He became enraged
Enraged.
and slapped.
Facts took place leading to the assault. In the fact, it is mentioned that Dandapan Jena, Kapilila Jena, Narayan Jena, Hon'Ble was present at that time of occurrence. They were trying to separate the quarreling parties, but none of them have been examined by the prosecution. Further, in the evidence of PW2 in Para 7, a cross-examination stated that all the eyewitnesses examined by the prosecution had seriously animosity against the accused and were interested in implicating the accused, and neither independent witnesses were examined nor any decision examination was given by the prosecution. The court would be justified in drawing and most important against the prosecution. Keeping in view the law pronounced in this decision, I will decide this case, although the eyewitnesses present at the time of occurrence have been named in the affair, none of them have been examined, nor the person standing at the time of quarreling were also examined. The presentation entails to prove the charge against the accused through the evidence of PW 1 through 4, who are known as the kings and kings of the deceased. In the circumstances, it is to be seen that how for their evidence is reaching to establish the charge against the accused.
Yes.
Another point is eyewitnesses named in the affair have not been examined, and PW 2-4 cannot say to be eyewitnesses of the occurrence. That is, there are post-occurrence
Witnesses.
that is there in Para 9. And another point is dying declaration. And dying declaration is disputed.
Very thank you.
Dying declaration that is there in Para 10.
Yes, from Para 5 is the witnesses. The day.
PW 5 is the witness who has stated about the dying declaration of the deceased. He has stated that deceased was taking cat for the piece for it, Hon'Ble, and he further told that accused Rogendra Singh assaulted him. But such statement cannot be believed for the following person, that the cross-examination strictly states Para 3 that the deceased told him that Hon'Ble, and so saying he passed criminal suits and could not say anything more. This statement in his cross-examination give a go by to the so-called dying declaration and made in chief examination. PW 1 to 4 being related to the dispute and were present near the and have not discovered. The deceased lay down on the ground and locked his hands, and in that condition, he was lifted to the hospital, in course of which he died. In view of such evidence, a dying declaration cannot be accepted.
Read 11 of them. 09, doctor.
Yes, medical. Madam, cause of death is due to impact of blow on the part of the body of the deceased, but by PW9 is opined that PW9, but PW9 is opined that that would be by fall of written papers.
So the cause of death is due to the impact of the blow on front part of the body. This is by the assault. That is by assault by Tenga.
But PW, if you finish finding then very much.
Yes.
Then next point is evidence of 1, 2, and 4 to understand that accused that appellant certainly dealt a Tenga blow on the chest of the that is para 12.
Yes.
Then intention to cause death to cause dangerously injury later time. That is final complete time. 15. Page 30. In a case and situation as reported, the decision, the Honorable Court has expounded the appellant had dealt by one blow by MO1 on the chest of the deceased. Had the intention to hurt it, he could add well this blows by MO1 on the head, not even the second blow was this on the chest. By dealing only one blow on the chest of the deceased, it could not reasonably be said that the appellant had the intention of hurting the death of the deceased or the intention to cause the danger. One blow had been dealt on the spur of the moment and after it started to hurt, not by the aim of
The finding is it's not a culpable homicide. Can't be culpable homicide because single blow is there. There was no intention. That's what the court says. So that is therefore 302 not acquitted. 304 part 2 was not acquitted. So 323 single blow. 325. Yes.
Your Honor, my submission is that since the finding of the crime has changed during the complete story was changed during trial. What was that story? That
Sand was thrown, he got angry, and
no,
then he called his uncle and all, and then thereafter they gave it to him. This is one story, FIR story. Second story is no, they were playing cards, and there was some quarrel. So therefore, he told his parents. Thereafter, they came. These are the two different stories. Yes, but the fact that there is a quarrel, that is not denied. Yes. How to get out of 325? That's the question.
when a year the weapon of the that has not been taken, that has not been proved.
Not Sibo.
And defense may have not been listed on the court of program. Tela and Fatwa are two different weapons. If a blow is given by a sharp edge of Fatwa, dealing would be possible. But not true if a person will fall over here, it would made up of on the earth to the cattle. Such type of injury like blue, which fracture is possible. No fracture, nothing from there. Only blood fracture.
Fracture is there for the page 51.
Injury number 2 is the fracture.
Yep, number 2 is the fracture injury. And fracture is there. Rib fracture. Fracture of 9th and 10th rib. That's the opening.
One speed, that's here. That can be
Where is that evidence? Take that evidence. Your star point is this. The eyewitnesses, those who have been named by the informant in the FIR, have not been examined. And the people who are standing in the time of occurrence, their name is also reflecting in the FIR and all. They were also not examined. The stranger to the incident, those are related to the deceased, have been brought in as witnesses. That's the strong point. They are related.
business to the direct
That's not belief. It is not belief.
PwC spoke of the first time. PwC didn't support them. And PwC also. And PwC is post of the PW9 is medical officer. Then PW10.
How will you get out of if blow is there, you are the witnesses are saying blow. Blow is there, and doctor says that to be fracture is there in the rib. 9th and 10th rib. Could be, but you, that suggestion is not made. You can't imagine things.
And
Record. Yes, sir.
and that is the most important part. That weapon is not.
Yes, madam.
Sure. I'll start with the PM report and the evidence of the PW9. The death is admitted, Your Lordship. The death is admitted, Your Lordship. Death is
But the
admitted.
finding is not human.
I'll just place 2-3 lines. Your Lordship. The story goes like this. There was a quarrel made related to the playing of cards or the throwing of the sands. One quarrel was there. Thereafter, the accused fled away to his house, came back with his family members, then assaulted the deceased. That is how the deceased died. And the assault was on the chest, that is the vital part of the body. So the intention to cause major injury is there. Further, the PW9, I'll just place the injuries for a minute.
Two injuries.
Two injuries, Your Lordship.
Yes. Second injury is the rib.
Second injury is
That is the cause of death.
that is the cause of death. And the suggestion they have made, if a person will fall over the pillar made of wood placed under the to tie the cattle, such type of injuries like bruise with fracture is possible. But there is nothing on record to suggest that kind of evidence or any metal witness or defense witness has been broken. And in the 313 statement also, he doesn't say so. Yes, sir. He doesn't say so. And PW 124, Your Lordship rightly said that PW 5, who is the supposed to be the dying declaration, he has
Not
also
believed, yes.
not good declaration. PW 1214, I'll just place 2-3 lines. And regarding
Why are we not examining the named witnesses?
I can't improvise the facts, and moreover, non-examination of the independent witness or other witnesses present there has not affected the prosecution case at all. Because the 124 read with 9 amply proved the case under the 325. I'll just
Non-examination is not, once the names are there in the FIR, you choose not to examine them and bring the relative of deceased.
because 1 to
They
4,
are not even eyewitnesses.
no, 1 to 4, 1, 2, and 4 are the eyewitnesses solution. I'll just place those.
Let us see what.
Yes.
He is the son of DPC.
You know, sir, it was 8 p.m. and the occurrence took place at around 8 p.m. in the village. It's very hard to find any independent witness who was not related to the deceased or anything else. I'll start with the PW1 for him. I know the accused was in dock in our village. The deceased named Banamba Raut is my father. He was killed by this accused in front of my house about 2.5 years back. The occurrence took place in the evening at 8 p.m. At that time, I was playing cards sitting on my veranda. The accused came there and wanted to take part in the playing cards. We refused him to play with us. At this, the accused gave 2 slaps to me. Then I entered inside my house and informed this to my brother and father. My father came out to ask the accused about this. The accused suddenly came to my father and dealt a Katua blow on the left side chest of my father.
So the story again, he went and called and all these things are not there.
Your Lordship, the previous quarrel, irrespective of relating to the throwing of
There is
sand,
no previous. He said that it's a continuing.
this continued, there was a quarrel between the informant as well as the accused. Then the informant went inside and called upon his father. His father came and confronted with the accused, and the accused on the dealt a Katua blow.
It is continuation of the
Yes.
same.
My father came out to ask the accused about this. The accused suddenly came to my father and dealt a Katua blow on the left side chest of my father. So he fell down, losing his sense. He also died at the spot. My father was taken to the Odoga hospital. The doctor declared him dead.
Yes.
So he is the eyewitness. So yes, in the cross-examination, there is nothing which could discard the evidence of the PW1.
The weapon is Katua.
The weapon is Katua, Your Lordship.
Let us see page PW2.
PW2. I'll start with the paragraph 2, Your Lordship. Banamar is the deceased. He died about 1.5 years back. The accused killed him. He dealt a Katua blow. Katua is, then he explains, Katua is Thenga blow on his left chest in front of my house, as a result of which he fell down and died at the spot itself. Katua Thenga is made of a stick wood that is used in agricultural work. Due to the heavy impact on Katua Thenga blow, he passed urine and stool at the spot. He tried to get back his sense with the hope that he lost his sense, but his sense did not return. We carried him to the Odoga hospital where the doctor declared him dead. PW1 Kalia Rauto was playing, sitting on the veranda. At that time, it was around 8 p.m. The accused came there and sat amongst them. Kalia and Rabi threw sand among themselves.
Yes.
So this is yes, sir. Accused gave a slap to Rabi. Rabi is the PW1 who is the informant in this case. PW1 stood crying. I myself, deceased Banamaro Rauto and Santosh Rauto came there. Santosh Rauto also came. We saw Kalia Rauto, Rabi Rauto and accused Jogendra Rauto were quarreling with each other standing on the village road. Accused was holding a Katua Thenga at that time. Suddenly, he dealt a Katua Thenga blow on the left side chest of the Banambaro and fled away. On such assault, Banambaro died at the spot. After the occurrence, I went to the Odonga PS with the Kunaja sponsor. This is it. Then I'll place PW4 and none of the witnesses.
Informant. PW2 is informant.
PW1 is informant.
But cross examination page 47. In the hearing of that my brother died, I went to PS and
Who is
orally
the informant?
prepared.
I stand corrected. PW2 is informant. Then I'll place PW4 for him.
But he gave in the FIR, he has given a different story.
You know, that discrepancy may be answered in respect of paragraph 3. When he said they both are playing cards, otherwise they're throwing sand. That polite. May I reread the sentence? PW1, Kalia Rauto were playing, sitting on our veranda. At that time, it was 8 p.m. The accused came there and sat among them. Kalia and Robbie threw sands among themselves. Accused gave a slap to Robbie.
Accused?
Gave a slap to the Robbie. I was reading the PW2 paragraph 4.
And PW4 now.
I'll start with PW4 now. The deceased Banambara Rauta was my father. I know the accused dog. The occurrence took place about 1.5 years back at about 8 p.m. in front of my house. On hearing the cry of PW1, I came to the spot and learned from him, from the PW1, that accused Jogi dealt 2 slaps to him. At this, I annoyed and assaulted the accused there. Gangadhara Rauta and my father also came to the village Dandok. The accused played away to his house. Again, he came to the spot holding a kathua thenga and accompanied by his brother Bhagavan Jena and father Sham Sundar Jena.
See, he gives a true story. He went back and then he came.
Yes.
But PW2 says that immediately it has.
He say, probably, you know, should may kindly see PW2, probably he was inside the house. To whom he was called upon by the PW1 to the spot, along with the deceased. That is why he doesn't know what is happening outside. On the contrary, PW4 who was outside, he saw this part of the story also. I'll again start with the PW paragraph 2 of the
fact that Tenga blow was
yes, on the chest. Yes.
That is consistent.
That is consistent. And
Find
PW4
corroboration with PW9.
PW9. On the contrary, it should have been. Doesn't matter. Doesn't matter.
Cannot be said to the eyewitness because they are post-occurrence witness.
No.
They say that they were there, they have seen it.
They have seen him assaulting the.
They are post-occurrence witnesses.
How would you say that? PW2 says that I have seen it.
PW1, 2, and 4, they are consistent eyewitnesses.
They have seen it.
But that has not been proved in Brahman.
Lordship, you kindly see.
The statement where the cross-examination I would ask.
No, Your Lordship, kindly see page 43 of the paper book. That is the cross-examination of the PW4.
Para 5.
Para 5, 1, 2, 3, 4, 5, 6.
By the time
I was present near my father when accused assaulted him. That was they have elicited in the cross-examination. The accused came from the behind of my father and dealt a blow by means of a kathua tanga. That is the cross-examination. And in paragraph, may I place the paragraph 2 of the PW4 for a minute? In paragraph 2.
He is very categorical in cross-examination.
That is admitted.
He says that the blow is just when he has assaulted.
He said that he was present
through the edge side of Katua.
Yes.
He fell down.
Yes.
Yes.
So PW1 to 4 are very much present on the spot itself.
But the sentence? 4 years.
4 years.
Undergone period? Tell me the undergone period.
You have a glance from part 9 that is phase of the judgment.
Yes. Yes.
EW214 cannot be said to be eyewitness. EW1.
Yes.
EW1 in part number D has stated that Julian Brown EW2 Sandra Brown EW4 came to the spot hearing the sound, and by that time the deceased was already dead. No view of this, it can be said that neither PW2 nor PW4 can be said to be the eyewitnesses to the assault on the deceased. Moreover, PW2 states in the para number 7 that by the time he came to the spot, the accused had been escaped from the spot after committing assault. This shows that the PW2 is the host of the witness. He has further stated had he been present at the spot and death of the deceased, as stated in the chief examination, you would not have made such statement. That is, hearing from PW1 about the death, he went to the PS. This renders the aspects of PW1 too having no direct.
I've already placed the relevant portion of the cross as well as the chief
There is
examination.
contradiction.
But
That's where the trial court picked up that part of the statement to
that
say
is a-
that he was not eyewitness.
Bishop, I have already see. Can I reread the portion of the PW 214, Your Worship?
Yes, really. I've seen that.
So this is a mistake on the part of the trial court, Your Worship.
No.
Could not happen.
Para 7, just see.
Para 7.
PW2. Page 40.
Yes.
On hearing that.
On hearing that my brother Banam.
On hearing that, he emphasized this.
Yes.
On hearing that.
Hearing that my brother Banambar died.
He has not seen. He has heard it.
Your Worship,
And I went to the PS.
orally reported the Your Worship.
I heard that from PW1. So and so. And this is not a fact that I have so and so. I heard it from PW1. So that is the two words picked up by the trial court to say.
I'll just answer to this. Your Worship. I'll just place paragraph 4 for a minute of that witness solution.
Yes.
PW1, Kalia Rauta were playing sitting on the veranda. At that time, it was 8 p.m. The accused came there and sat amongst them. Kalia and Ravi threw sands among themselves. Accused gave a slap to Ravi, PW1. PW1 stood crying, I myself, deceased Banambara Rauta and Santosa Rauta came there. Santosa Rauta also came. He saw Kalia Rauta, Ravi Rauta and accused Yogendra Rauta were quarreling with each other and standing on the village road. Accused was holding a kathua thenga at that time. Suddenly, he dealt a kathua thenga blow on the left side of the chest of the Banamar and fled away. On such assault, Banamar died at the spot.
No, this paragraph is all right, but 7th creates a problem.
I'll just answer see the FIR for a minute.
Punna Acharya examine. Punna Acharya.
I'll just check. No.
Yes. PW4 is also not eyewitness according to.
No, PW4, Your Worship, PW4, in the cross-examination also, he says, I was present near my father. No, Judgment is just a
Appreciation.
appreciation of
I have
evidence.
to
Your
see the
Lordship.
right
Yes,
appreciation,
yes,
huh?
Your Lordship. In PW4, in his para 2, he stated that he was present at the spot. He saw the accused assaulting the deceased. In paragraph 5 of the cross examination, they have elicited that when the deponent is saying, I was present near my father when the accused assaulted him. The accused came from the behind of my father and dealt a blow by means of a cutting.
You're standing in front of him.
Yes, sir.
Yes. Yes, anything? Undergone period, just tell me. Period undergone. Yes, madam?
I'm just checking.
Period undergone. How much period have you undergone? 3 months, 7 years. 9 days.
3 months, 7 days.
3 months, 7 days. What is this? Is
Now
Around 50. 52.
is anything you want to finally written note. Because you have argued so well, at least prepare a written note and give it. Huh? Written note. Write down the name of madam. Prepare a written note. Whoever said what are the points? Your first point, as I understood, is named if witnesses are not examined. Second point is the story put forth by the witnesses in the FIR and it is different. And the witnesses PW2 and 4, which the trial court has relied upon, they are not the eyewitnesses. They are interested witnesses. Para 9 for that you have relied upon, like that. Okay. It's all right. Perfect. If you want hearing, I can put it day after tomorrow once again, if you want. Day after tomorrow once again. If you want to add anything, you can add also, no problem. I can put it on day after tomorrow. You come with your written note, we'll refresh it. That's a better idea. Day after tomorrow, along with written note. Huh? Take. Partly heard. Let me counsel for the appellant. Give your name. Counsel for the appellant submits that you would prepare a written note of submission and advance further argument on next Tuesday. Wednesday. Yes.
May I depart?
Yes. Better.
May I be pardoned? My lord, sir, item 47, the 94 matter. The first of your lordship has passed over that matter, thinking that somebody will appear, or else your lordship will appoint an amicus curiae.
Which matter? 47.
Item 47, appeal 85 of 94.
Very old appeal.
Old act, my lords.
Old act, no?
Yes.
I'll appoint someone. It'll be the one. I will appoint someone. Yes.
Should we call this matter on 18th? 18th.
18th, huh? Don't so consistently counsel for the. Okay.
18 minutes.
18.
Wait.
47, 18. So appointed amicus curiae. Yes. Yes. 16, 17, 16, 17. Mm, mm. 16 and 24. Okay. 16 and 24. Yes. 16 and 24.
6 and 7. Item 7.
Ready? Who is ready? Perfectly. Mr. Jafarullah, you are ready in any matter? Okay. 48.
48.
70. 48 in your report.
48.
My lordship, yes, my lordship. 48, my lordship, I am just showing that Nityananda.
One
Yes,
that.
he was died. He was the sole appellant because my lordship can have a glance to the judgment page number 20.
47. No?
Other accused are under UTP, my lordship. They have already undergone, and for that, my lordship can have a glance to the judge.
Why they filed the appeal then?
My lordship, I'm just showing. Page number 20, my lordship, of the judge.
20?
Yes, of the judgment.
Okay.
The record reveals that so far the convict in serial number 2 to 7 are concerned, they are sometime in jail custody during trial. I think it will be meet the end of justice if they are awarded sentence to the period already they have undergone as UTP. And my lordship, and according.
All right, they are challenging conviction.
No, I am just saying, my lordship, because he has applied for the interim bill and the sole appellant was tried. That's why my lordship only. And these people are.
They have also challenged the conviction.
Yes, these people are under section, my lordship, only 323, 341 and 34.
But it's all right, but one of the appellant died. The other people are sentenced already undergone, but they are challenging the conviction.
Yes, my lordship. That
Challenging the conviction.
only acute.
Who is appealing?
Because he was convicted for 10 years, 3042. Partly.
Non-appeals for the 47, no? 48. 48. 48, no? Mr. Dhaul's office. Huh?
He was there right
You are in Mr. Dhaul's office? He is 48, what do you say? See, one appellant has died, Nityananda. And in so far the other appellants are concerned, they have been convicted, but their sentence is converted to already undergone.
Yes.
So if you really interested to argue on the question of, conviction, then we can hear it. We ask, put it on Monday, Tuesday, Thursday. Otherwise, it can be disposed of.
Yes.
It can be disposed of. Right off. There are 48. The present appeal is filed by seven appellants, assailing the judgment and the order from the pursuant to the order dated 24/7/2025, the report has been placed on record. As per the report dated 13/7/2025, the appellant Nityananda Mishra has already expired. Therefore, in the absence of provisions, any application under section 394 CRPC by LR or next friend of the said appellant, the appeal for him stands abated. This is Sarita Bharana, counsel for the state, by referring to the order of sentence passed by the trial court, submits that the appellant number 2 to 7, although were convicted for offence under section
323, 341 and 34.
34. However, they have been, however, no sentence is awarded as they had by the time the judgment was passed, they were already undergone substantive period of sentence. Therefore, their sentence has been set up. In that view of the matter, in that view of the matter, Sir submits that nothing survives in this appeal. And we say so appears and submits that he would seek instruction regarding the instruction as to whether the appellant number 2 to 7 are interested to contest the appeal. Contest appeal against the conviction. These matters.
My lordship, another.
He understood. He understood what I said. No, he didn't. So there's calling. In item 48, it is your case. What had happened is there are 7. Right. No, there the sentence is already under. So therefore, I'll dispose it up.
Yes.
I'll dispose it up. Let me go. Mr. Dhar, appeal along with so that ऐसी वो paragraph उतार देना para 20 ना
Page 20.
Submitting page 20 para 2 the record remains. সেটা उतार देंगे करते देखे जाना तुमको ठीक है so appeal dispose up appeal dispose. Yes. 46.
My lordship, item 46, my lordship, there is the prayer is for the confiscation of the vehicle, my lordship. And my lordship, it is 96 matter. And now, my lordship, I have got the report and he is saying he don't want to.
40?
46, my lordship. The appellant has given this report, my lordship. Because the car must have been the ambassador car. And because
It is that he has not filed anything.
yes, my lordship.
He doesn't say that. Sole appellant has assailed the order dated, assailed the judgment dated. What is the judgment date? Into when judgment. You don't have a judgment, no? This date is doubtful. He has been convicted for offense under section 20B1.
As to the prayer of the appeal, my lordship.
The order of prosecution has been passed under section 452 of the Code of Criminal Procedure satisfied from securing registration of the so and so has been seized in connection with the case and directed the position of the same car to the felon. This is only the bill, or only the release of the car, nothing else, my lordship.
Convicted, what is he asking? Who is he? What is his name? Radheshyam Singh. Acha, he is the owner. Oh.
His brother is convicted under
Brother is
section 22B, yes.
The accused is Jay.
Two people are there.
Jay Prakash.
Yes, two people are there. One is the driver and the it was filed only for the release of the vehicle.
Where? One, Jay Prakash Singh was prosecuted for alleged commission of offence under section 20B1 of the NDPS Act 1985. The prosecution is against the said accused. That also the present appeal has been filed by one Radheshyam Singh. Radheshyam Singh challenging the order dated. Challenging the order dated. Challenging the order dated 10/12/1993, passed by Sessions Corporated Jaipur in Sessions case number 94 of 93, rejecting the application under section 452 CRPC, seeking the release of the seized confiscated ambassador car. Next one. The background of the case is that one Jay Singh was Jay Prakash Singh was prosecuted for offence under section offence under section 20. The prosecution alleged that the Jay Singh Allege that, on 30th 12 1992, 30 bar 1992, the accused was carrying contraband ganja in ambassador card bearing registration number MRH 4275. And he was apprehended by the police, and the 20 kg of ganja being carried in the dicky of the shared car was recovered from him. He was put to trial. Eventually, by the judgment and order dated 16/10/1993, the said accused have been convicted by the Sessions Judge CORAM Jaipur in Sessions case number 94 of 1993. The present appellant and moved an application under section 452 CRPC for release of the vehicle, which has release of the ambassador car bearing number so claiming to be the owner of the car. However, by the impugn order dated 21/12/1993, the said application has been turned down. Agreed by the rejection order, the present appeal has been filed. By the order dated by the order dated 1/7/2025, a report was sought from the Sambalpur Superintendent, SP Sambalpur, regarding the well-being and whereabout of the appellant. Pursuant to the said order, a report has been placed on record at the instance of who is that? At the instance of IIC Khetrajpur PS by report dated Parasapo the reports. As per the report, the appellant is not interested to prosecute the case anymore. Taking into consideration, having regard to the submission made by the counsel for the appellant and counsel for the state, nothing survives in the appeal. Accordingly, same is disposed of. Disposed of. Yes. 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 $57.
61, 62,
57.
So, these persons have been convicted in trial. With regards to other fields, those banana and distributed by that are condition.
But this is sole appellant, Aurobindo Singh Dev. The other appellants have died or what? Acquitted. Maybe acquitted. All three of them. The appeal is.
I think one mistake because considered that have not been functioned out. Conviction was 7 years. Appeal should have been filed before the sessions court. Instead, it has been filed here and nobody pointed it out. It seems better. They must have filed appeal there.
The other accused persons.
The earliest point, well, yeah, now I'm well, verifying why they have not filed 7 years conviction is there. No. But in that, whatever whether it's a case.
Now, let us understand what happened.
My Honorable friend can apply the instruction papers.
Yes, madam.
Instruction. Regards to the other two, namely Santosh Parana and Vishnu.
Right on. Right on. Three accused persons, namely Santosh
Maharana,
Marana,
Vishnu Charan Nayak,
Vishnu Charan Naik, and the present appellant were put to trial for alleged commission of offence under section 398 or 34 IPC, read this section. I'm sorry. Okay.
By the assistant, but the assistant session judge
all the three accused persons have been convicted and sentenced by a common judgment dated 6 January 1996 by the assistant sessions judge Raigada. Naganja, what is that? Atagod. The present appeal is being preferred by one of the convict. Mr. I've seen that 19-1. 6-1/19-1. Mr. Dhal, learned counsel for the appellant, senior counsel for the appellant, submits that insofar as the other two convicts are concerned, it appears that they might have filed the appeal before the sessions court. The state council is directed to verify as to whether verify regarding the status of the challenge, status of the challenge being made by appellant number the co-accused Santosh Marana and Vishnu Charan Naik. Release the matter. A good week for you just whether these two people have already challenged. If they are acquitted, challenge and acquitted, something might have happened. We will see and dispose up accordingly. 96 matter. And you must get the information. Maybe there any matter out.
3 years.
Item.
Seventh point. What is seventh?
77.
77. Small matter.
And the charge was
You have the file. 77. Ready.
Looking at in 325
Yes.
Initially, I was, the address was not in the affair. But for the lawsuit of the affair.
Yes.
Conception of the agency started with the daily report the library report in the Ajit in the rising grammar subtitle attack on the book. According to cherry pin cherry somebody. Most angles the job of the family, Sundar Rami was properly. They manager two cherry cream, some slides are used by us, and immediately after they assaulted.
No, let us see first. Conviction under section
325.
325 only.
325.
323 IPC. And sentence?
Sentence for 325 1 year.
505.
Undergone?
Undergone period matters. Tried 4 days after conviction.
Huh?
Duly tried 4 days after conviction 21 days.
4 days.
Duly tried arrested on the regular usually.
And conviction for it?
27 to this is not the judgment and paid by this honorable court 20th March 2007. It is 21 days. Total is 25 days.
Yes. Now you are reading FIR. Yes.
Date of occurrence is 30 July 2001. Allegation while they were negotiating while purchasing these two appellants assaulted first one the PWP, whose name is Jogobondu Pandi, and thereafter we ran away. These two assaulted this PW code will be informant. And मेरे एक स्पेसिफिक मतलब सॉरी तो मोरा दामना सब तो को भांगी देले ओ पानमा तो बाबुली को मारो कोई अच्छी पिठी को मतलब ठेंगा से तो मारी वो पानमा बोलो को मतलब मारी गयो वो तळे पड़ी गयो वो ताको नाम जानि ना से माने पहले पारटा ग्राम पंचायत करो पदार फोटो ग्राम लुगा बेपारी हो उक्त समय रे नंदपुर ग्राम श्री गणेश किलो who is the PW1 and others who are named in the FIR not examined.
Yes.
ସେମାନଙ୍କ ମଧ୍ୟରୁ ନାରାୟଣ ଥିଲ ରାମ ମହାନ୍ତଙ୍କୁ ମଧ୍ୟ ମାଡ଼ ମାରିଛୁ ହୋଇଅଛି ସେମାନେ ଆଦିବାସୀ ଜାତିର ଲୋକେ ଜଣା ପଡ଼ିଛି thereafter ମାନେ police took up the investigation. Initially the IO is number PSI who is PW11. Well, before going to that may I request the medical officer
PW?
PW 10. On 27/2001, I was an assistant surgeon in the state hospital in CORAM. On that day, some police supervision, I examined one Sudev Pandi, who is the informant of village Nandapur, and found the following injuries on the person. Such as the CORAM from the ulnar borders. The injuries were red in colors. Lacerated injury site of 5 into 5 into 5 over right hand. Then I advised X-ray of the said injury. After going to the X-ray plate, I found fracture on the hand of the second metacarpal. So after he aforesaid, I came to opinion here the injury number 1 is simple in nature, injury number 2 is grievous in nature, and the age of the injury is 24 hours of my examination, and I could hence caused by ardent blood report. But I would like to bring your notice that the examination of the deposition by itself is 37. Well, kindly see the FIR. It is registered on 31st July 2001 at 9 a.m.
Even 31st?
July 2001 at 9 a.m.
Yes.
Even the deposition of the PW11 says, may I read first? On 31/7/2001, I was ASI of the police station attached to Padua Peace on that day.
No, but incident took place on 31/7/90.
No, ma'am, it's 37/2001.
FIR is next day.
FIR is the next day.
And
Examination on the same day of the officer.
Same day.
9:35 PM, my lords, action.
yes, that's
Medical
right.
examination report, which is at
After that, the FIR was reissued. After that.
9:30, page 91, my lord, of the PCR. But all the evidence says that the FIR was registered on 31st. Even the PW4, and I read, my lord, the PW4 statements, my lords.
Who is he?
Informant. PW4
Who is he?
is the informant. He is the informant and the injured person. Initially, he doesn't know the names.
Injured, yes. What does he say?
I know the accused person standing in the dock. I am the informant in this case. I am Dumbo by caste, which comes under scheduled caste. Accused persons belong to Rana caste, so they do not belong to SC or ST at about 4-5 years. 3 PM. I was going to Raising Market to purchase goat. One Jagobundu Pangi was also accompanying me. He was going nearer me. These accused persons were abusing Jagannath Pangi. I don't know who, it is not disclosed who is Jagannath Pangi. As such and such, asserting by lathi and chain.
Okay.
When I protested them, leaving Jagannath Pangi, they assaulted.
Jagannath Pangi was not examined.
No, my lords. Jagabandhu Pangi was examined, who is PW3.
But Jagannath Pangi was stated to have been assaulted.
My lords.
He is not examined.
I protested them, leaving Jagannath Pangi. They assaulted me by means of iron chain, lathi to my head. But my lords, from the medical examination, there is no injury on the head. Due to my raising of hands, the lathi assault fall on my hand. I sustained injury on my left hand. There is no injury on the left hand, my lords. And right hand on palm portion, as well as cut injuries on the other parts of the body due to assault. My lord, there is no injury on the other parts of the body, my lord.
Yes.
There is no cut injury also. My lord, the assault of human is Henga and the iron cycle chain. As such, assault, I sustained injuries. They also accuse me in such and such. Knowing that I am a Dumbo by caste, they abused me. My hand was fractured. Ganesh Killer, who is the
Fracture injury is there.
My lord?
Fracture injury is there.
Fracture injury is there.
Yes.
Ganesh Killer, who is PW1, who turned outside, my lords, had seen this occurrence. Apparao reached the spot afterwards. Apparao is not examined in this case. After this occurrence, I lost the FIR in the police station. This is important. One scribe typed the FIR as per my statement and affixed my LPI because of the injuries sustained on my hand. I could not write FIR with my hand. I know reading and writing. Exhibit such and such is my signature, injuries conducted. I also affixed my LPA on the medical examination report and the equation.
Yes.
But then the next part, in the cross examination.
I may pardon, my lord. One person has been skipped. That is, I sustained injury on my left hand and right hand also. Both.
That's right.
That has been.
But there is no injury on the left hand.
Maybe, but in right hand that is injury. There is injury.
The FIR was scribed by the police inspector as my instruction. Now this is contrary to the previous statements.
Scribed by someone else.
Someone else. It is a fact that in my FIR I have not named the accused person because at that time I was unaware of their names, as they belong to another village. I have not cited the names of other witnesses seeing the occurrence in my FIR. The accused persons are selling clothes. It is not a fact there has been any case against me at the course of the corruption started by the accused persons. Well, these are other allegations where he is denied. But the another injured person is PW3, who has not examined, not been medically examined. The Jagabandhu Pangi, who is alleging that he is also being assaulted. Well, there is the position of that PW3.
Yes, I'm there.
I know the informant Sudhir Pangi. He is my co-villager. He belongs to Dumbo by caste. Who belongs to Harijan caste, SC. I also know the accused person of this case who doesn't belong to scheduled caste or scheduled tribe. This occurrence took place about 4 years back at 2 PM at noon. I and Sudhir Pangi has gone to the rising at the purchase board while we were bargaining to purchase board. Accused Trilok Thoda assaulted me on my head
with a lathi causing bleeding injury. He also abused me in the obscene language such and such. So out of fear, I ran away.
Yes.
And these accused persons also assaulted Sudhir Pangi by means of lathi on his head. When he ran away, how could we know that this person assaulted the Sudhir Pangi? The accused person used to sell ready-made sari and dresses in that weekly market. Again, say both the accused person abused us in the opposite manner.
Yes.
So by saying I ran away, again said that I have been assaulted in the same manner. The abuse has been fully considered that we belong to scheduled caste. Well, in this case, there is no motive of the.
What is the reason of attacking?
There is no motive. It is normal in the cross-examination. Later on, Sudhir Pangi was treated in the Bedford Hospital, Koraput in the arrest assault. It is not a fact that accused person have filed a case against me. It is not a fact that these are the denials. Well, the main part is the date of the FIR and the medical examination, which corroborates each other matters. And the statement of the IU, the BW11, the subsequent IU, who is the OIC, he himself said that the another thing, my lords, I would like to draw your kind attention, my lords. The BW9, who is the OIC, my lords. I received a written report, my lords, which also contradicts the previous statement of the
Who has written written report? Means that scribe might have written and given, but he says that I gave it to police.
In the PW4, my lords, in the cross-examination is stated at paragraph 2.
He says two things. One is scribed by someone else. Second, again, he says that no, it is written by the IH police.
Plus another thing, as per the PCR, my lords, look at the page number 91, my lords, the injury.
Injury?
Injury, my lords, injury report of the
Exhibit. '91. They got 91.
opinion is, my lords, injury number 1 is simple in nature, may be caused by hard and blunt object, maybe within 24 hours of the duration. And the injury number 2 is the grievous injury, may be caused by hand and hard and blunt weapon, maybe within 7 days of the duration.
Okay. The previous injury it must be.
That might be a previous injury. And the statements of the PW2 and 3 is contradictory to each other. Now, while deposing the PW4, while deposing that, I have first I went to the police station in one statement. PW3 is telling that he took the PW1 is telling that he took the PW4 to the hospital. But PW4 himself saying that I went to the police station, thereafter I being examined. If my lords, he went to the police station on 31st, how can he be examined on 30th?
Yes. Any other vital points?
So the DW1 is examined, my lords. Who deposed?
What was your case in 330? 313, what have you said? Okay, I'll prepare small note. I'll hear it out. Yes. Take. For note. For note. Get ready because see, the 2-3 points are very important. who has scribed the FIR is doubtful. PW4 in one place says that scribed by someone, I signed it. Secondly, in the same breath, he says that no, the IIC has prepared it. When IIC was examined, he says that a written report was received by me.
Was received.
The genesis and how the FIR has been written and who is the author is not coming forth. And the medical examination says that second injury is caused 7 days before, which is grievous one.
But
Immediately in the same day he was examined.
PW in his statement.
But
he
you
has
see exhibit. If you see the exhibit, medical report, in the report he says that the injury might have caused 7 days before.
grievous artery.
So it's the previous injury. These are the two very, very important points, you know.
The effects of medical exam on 30th.
Yes, before 1 day.
Before,
That may be after
because
examination.
occurrences
FIR
on-
is registered.
occurrences on 30.
Deposing told that I first lost the FIR. Thereafter
That's
police
right.
report
That's the
later.
contradiction.
He has been examined first in medical, thereafter lost.
No,
the
that's
FIR.
right. But he says that first I gave the report, thereafter I am examined, which has come first. So the FIR is doubtful when it was registered.
FIR is on 31st, but event is on 30th.
31st, who has written or not, all these things required to be seen. No, we'll see.
I 18 years. In the pattern method, I am totally 5%, 80% something.
Well, here.
Item 20 ownership, item
I'll
20,
hear.
item 20 ownership, and already submitted the report.
Yes, all report you give.
I-